Okay, at the first time, what we call the return date, it's normally a very short hearing. Normally a 15-minute hearing before a master. If the matter has to be explored substantively and cannot be disposed of during that short time, the summons will be adjourned to a later date for substantive argument. The court will estimate the time needed for the later hearing, what we call the substantive hearing, and give other directions as necessary. Normally, some typical examples of directions may be, yes, the summons for the Order 14 application be adjourned to give a date, right? 6 weeks later, 8 weeks later, let's say to May 15, for example. 15th of May 2021. Let's say if the defendant hasn't filed an affirmation, then the defendant be granted leave to file an affirmation in opposition within 28 days from the date of this order, and the plaintiff be allowed or be granted leave to file an affirmation in reply. Now sometimes there is, just like the pleading, sometimes there is the applying or the summons and affirmation in application, the defendant's affirmation in opposition, and sometimes the plaintiff may even file a affirmation in reply. Okay, but that's not mandatory. Okay, the third one is not mandatory. Adjourned hearing. Okay, we talked about the return date, which is the first one. The first time we come before court for that particular application. The adjourned hearing or the substantive hearing is when the parties argue, make their substantive arguments, why it should be granted, why it shouldn't be granted, and so on. A typical substantive hearing would be 2 to 3 hours for Order 14. Typically, you don't have to remember that, but that's just, in practice, that's what normally happens. Now, there are 4 possible outcomes for an application. First, the worst for the plaintiff is the plaintiff's application is dismissed. Okay, meaning not allowed. Okay, no judgment granted. Second one, the court gives the defendant unconditional leave to defend. Third one, the court gives defendant conditional leave to defend. Fourth, court gives judgment in favor of the plaintiff. So which one is what the plaintiff wants? Which one? Number 4, right? In favor of the plaintiff. Summary judgment granted. Okay, that's the ultimate goal of the plaintiff. Now notice number 2 and number 3. Which one? Well, both of them, under both of them, both of those outcomes, defendant is granted leave to defend, which means the case continues. Okay, that means, first of all, no judgment granted for the plaintiff. Secondly, the defendant is granted leave to defend, to continue fighting the case. Sometimes, if the defendant hasn't filed the defense, leave will be granted for the defendant to file the defense. Okay, consequential directions. Now, between 2 and 3, which one would the defendant prefer? Unconditional, right? Nobody wants conditions attached, especially normally the conditions involve payment into court. Right? Okay, so 2 is more favorable for the defendant. Although 2 and 3, under both 2 and 3, defendant can continue with the case. Now, number 1 is, I will explain a little bit more later, but basically, also no judgment for the plaintiff. Okay, the defendant will also be having leave to defend, but 1 is a more serious consequence for the plaintiff. Under number 1, what the court is really signaling is there should never have been an application by the plaintiff in the first place. Perhaps it's so obvious the factual disputes are very unclear and very complicated. The plaintiff should have never made the application. Worst, perhaps some criteria has not been met. Perhaps the time limit's not due, and after the AS, perhaps it's a fraud claim, specifically not allowed for Order 14, or some procedural stuff is missing. Perhaps remember the sentence, I believe the defendant has no defense, perhaps that's missing in the affirmation. Something's not right. Okay, so one is is a bad news for plaintiff. Normally, plaintiff will be made to pay cost for the application because they shouldn't have brought it. For number 2 and number 3, normally, guess what? Now, when something is undecided because the case continues, I'm trying to instill into you the rationale so you remember it easier. If we're saying, yes, defendant, you continue to defend. Apart from whether made to make payment into court, there are also cost implications. I already told you for number 1, plaintiff shouldn't have made the application. So plaintiff will pay the cost for this Order 14 application, not the whole action, just for this application, right? Because plaintiff shouldn't have made the application. So made to pay the cost of both sides. Number 2, number 3. Okay, let's grab those 2 first. Number 4. The court gives judgment in favor of the plaintiff, so the plaintiff celebrates. Okay, who do you think is paying the cost? Defendant, right? Because basically the plaintiff has won on the application. Do you agree? Right? So the winning party gets paid the cost normally. And when you deal with cost, distinguish between cost of the application and cost of the whole action, entire action. Now, if I tell you, well, if the plaintiff gets his judgment, final judgment, right? Hooray. The Order 14 application, you're correct. The cost of the Order 14 application is going to be paid by the defendant, right? You just said that. How about the entire action? Because we're wrapping up the action, remember? Right? We're getting a final judgment of the case, so the entire action is wrapped up. So who's going to pay the cost? Defendant, because ultimately, in the whole action, the defendant has lost. Right? Final judgment entered in favor of plaintiff against the defendant. So defendant lost. So if this is given, defendant will be made to pay the cost of the Order 14 application as well as the entire action. Okay, makes sense? Under this too, well, whether the defense case is strong or not, they're given leave to defend and continue to fight the case. So we won't decide on the cost yet. Normally, it's what we call cost in the course. Okay, not both the same spelling. C-A-U-S-E. Okay. It's going to be on your PowerPoint slide anyway. Okay. So we don't decide yet. Let's see who won the case in the end. Whoever wins the case in the end will also get the cost for the Order 14 application for number 2 and 3. Okay, let's look at it again. Remember number 1 is where I said it should never have been brought. Okay, the application for summary judgment is abundantly, very much unsuitable, and that the plaintiff should be aware of such. Okay, so they should never have brought the Order 14 application. The matter will proceed to trial. The normal cost order would be the defendant's cost. okay, against as being paid by the plaintiff for this application. Number 2, unconditional leave for the defendant to defend the case. Now, unconditional is better for the defendant, right? That's what we just said. No conditions attached, right? So better for the defendant. The defendant, why? It's because the defendant has demonstrated a triable issue or arguable and bona fide defense. Remember what bona fide means? It means genuine. Bona fide means genuine. Okay, this word, this term here. A genuine defense. Or the court has doubts or suspicions about the plaintiff's case. Okay, so it's a matter of relative strength between the plaintiff's case and the defendant's case. Okay, either the defendant has quite a strong tribal issue, or the plaintiff's case is looks a bit suspicious. In both cases, the defendant will be given unconditional leave to defend. Normal cost order is cost in the cost. Okay, that's what I was writing. Cost in the cost, meaning we will decide in the end when we see, okay, whoever wins the main action in the end will get the cost also for this Order 14 application. Okay, whenever the court gives leave to defend, the court will give consequential directions on further conduct of the proceedings. Okay, such as going onwards, who's going to file what documents and so on, and timelines and so forth. Number 3, also defendant is given leave to defend, but this time in this scenario, the defendant's case doesn't look so strong. Remember we said the hurdle is quite low for defendant to be able to continue the case and fight the case? Because we don't want to knock him out unless we are sure. So as long as a defendant can have some tribal issue, we'll give him leave to defend. But if the defendant's case is very weak, very fishy, means shadowy, right? Suspicious. This time we're saying the defendant's case is suspicious, but just sort of make the hurdle, so we'll let him continue to fight. But it looks really suspicious, so we're going to attach conditions. Okay, so even if the defense asserted by the defendant is possible but shadowy, conditional leave will be granted. Okay, normally those conditions involve payment of money into court. The court will normally give consequential directions also, right, whenever leave is granted to defend on further conduct of the proceedings. Reasonable conditions to the grant of leave, mostly to provide security or payment into court. They mean really similar things. But an impecunious, it simply means poor. Okay, it's just a long word for it. Okay, impecunious. Just thinking it will make our English sound better. Okay, an impecunious defendant may resist such conditions. Because as I said, the court doesn't want to be oppressive. If the defendant, but unless the defendant is impecunious and can prove to the court that he's impecunious. Otherwise, if there's conditions attached and the defendant fails to comply with those conditions, the plaintiff can apply to enter judgment with cost. Because when the court gives directions and say, we'll attach conditions in order for the defendant to get leave to defend, normally it's in the form of unless orders. So unless, for example, a typical one, you don't have to note this down, but a typical example would be, unless the defendant pays into court $500,000 within 2 weeks of this order, the defendant will be barred from filing the defense and judgment will be entered in favor of the plaintiff, something along those lines. So it's normally in the form of unless orders. So unless you comply with that, you'll be barred from the chance to fight your case, essentially. Normal cause order, remember, we don't know the result of the case, so we're gonna have cause in the cause as the cause order. So see who wins in the end. Judgment in favor of the plaintiff, revisited. So the court is agreeing or holding that the case is suitable for summary judgment and the defendant fails to show an arguable defense or raise any triable issues. So judgment would be entered. Normal cause order is cause B to the plaintiff and not just the Order 14 application, in fact the whole action. Now the last point there, normally fixed cost. Now notice the word normally, because normally the plaintiff will try to apply for Order 14 application as soon as possible, right? To save costs, to save time, get the money early, and so on. So normally by the time the Order 14 application is made, it's still early in the whole civil case. Yes? So the cost is normally not so high yet. It hasn't accumulated to very high levels yet. And the court normally makes a summary assessment in a lump sum, okay, to wrap up the matter even sooner. So in real practice, again, you don't have to remember this, in real practice, when we actually go to the hearing of an Order 14, the solicitor behind my back for the plaintiff would have prepared a statement of cost, what we call a statement of cost. So what the plaintiff has expensed as legal costs so far. And if we get this favorable judgment, I'm going to tell the court how much I've incurred so far. The court normally make a very broad brush approach and say, if I say 65,000 so far, because I've only done the writ, the SOC, and probably this application, right? Limited amount, unless I've used a senior counsel or something, right? So the court normally make a broad brush approach, and if it sounds reasonable, the court will make a summary assessment, just arrive at a lump sum, and make it a fixed cost. So the whole matter can be dealt with together. Okay, for the whole action, the fixed cost can be for the whole action, plus including the Order 14, because the whole case finished, right? Apart from enforcement, of course. Now, as with default judgment, you can also apply to set aside a summary judgment. A defendant who did not attend the hearing of a summary judgment application may apply to set aside the judgment. You need to explain why you didn't attend. And just because you were absent and now you're back, you still have to show that you have a bona fide or genuine defense or tribal issue, right? Ultimately, that's the test. Okay. And I guess now here we didn't say, notice here I don't say, is it, we don't look at bona fide, whether, what do I say, regular, irregular, etc. Right? Of course, it can be one of the argument if it had been a irregular judgment as well. But normally by this stage, notice that what's one of the criteria for a precondition? The AS has been filed by the defendant, right? So the defendant actually knows of the proceedings. So there's a lesser chance, and we don't focus as much on regular judgments, irregular judgments, right? Because the defendant must have been aware of the action to be able to file the AS. Okay, and here we focus more, notice the focus is on the merits. Whereas in default judgments, Order 13, Order 19, we're focusing on the compliance or non-compliance of procedural rules and time limits. Here, if the defendant can really show a genuine defense or tribal issue, we'll let him have his day in court, okay, and continue to fight the case. Any questions? Okay, reflection activity. We're close to the end. Yes, we're close to the end. Okay, again. Using the facts provided in the 4 cases, I think it's the J and M, right? At reflection activity 1, at the end of 8.2, explain the results if plaintiff J had applied for summary judgment in each case, and assuming you were the master hearing the application, what specific orders would you give? So where were we? Got it here. Case 1, the simple thing about contract between J and M to supply for goods within 2 months, failed to deliver after 3 months, so no delivery of anything. J asked for return of deposit, 100,000. We said this scenario was clear cut, didn't we? Clear cut? Okay, clear cut, you're the judge, so what orders would you give? Final judgment or summary judgment in favor of the plaintiff. Cost order. Cost to the plaintiff. Cost of the Order 14 application and actually of the entire action be to the plaintiff. Normally, fixed costs. Normally, okay? If, of course, the case has progressed very long onwards, before the plaintiff actually made the application, perhaps it's harder to make a summary assessment of fixed costs. And it may then go to what we call a taxation master to assess the reasonableness. Okay, so scenario 2. I think this is the one with the alleged misrep. Okay, misrepresentation. Okay, so hard to say, right? So do you think, well, what's the test again? Whether the defendant has a triable issue is one, and arguable defense or bona fide defense. Okay, if you've raised either limb, you can get your leave to defend, but I normally just like to say both anyway, just to be sure. Okay, so here, do you think the defendant has raised an arguable defense or triable issue? Triable issue? Probably, right? The misrepresentation that we mentioned. So if there's a triable issue, the likely order would be that the defendant be. Well, do you think it's shadowy? Well, once you decided, yes, there's a triable issue or arguable defense, then you have to decide also whether it's strong or not. Right? Strong or quite believable or shadowy. Right? How good is the defense case, do you think? Is it fishy and shadowy and suspicious? Or does it sound genuine or possible to be genuine? Opinion? Who thinks it's suspicious? I think it can work up to a pretty good argument, right? So I would say it can sound to be a genuine one. So conditional or unconditional leave to defend? Unconditional sounds quite capable, right, of being, well, at least capable of being true, and doesn't sound very fishy. Okay, so unconditional leave to defend, normal cost order, cost in the cost. Okay, cost in the cost. So let us see who wins at the end. Case 3. Well, M claimed to need further months Okay, further 3 months to be able to complete the production. Right? M has raised some sort of issue. We're not sure whether it stands up to be a good argument. Right? It's a little bit weak. Then we say, well, is it just a unilateral, one-sided attempt to vary the contract? If we think it's very weak, what order would we give? Conditional leave to defend. Okay, so conditional leave to defend, normal cost order. Still, cost in the cost. Okay, so you get it. Okay, the round and round of J, dishonored check. So I would just say J paid deposit late. M can show an email saying, yes, it would really be delivered late because you paid the deposit late. So complex factual matrix involve credibility issues of witnesses. What order would you give? It can be dismissed or unconditional leave, okay, depending how strong the judge's view or the master's view is. That is it totally abundantly unsuitable? Normally, the master is not so harsh. Okay, you are correct. It can be dismissed. The summons or application dismissed with cost, or it can be unconditional leave to defend. It can be either scenario, depending how bad, how unsuitable it is. Okay, here it has credibility issues, but it's likely in a real life case that both sides argue as if no. As a plaintiff, I'll argue no. Of course, there's no credibility issues. The other side, of course, will argue the other way around. So depending how strong the arguments are, so both those options are possible. Okay, both of those outcomes again. Either plaintiff's application dismissed with cost or unconditional leave for defendant to defend. Okay. Appeal. Summary judgment applications normally heard by masters. To appeal, you appeal to a judge in chambers. Okay. Judge in chambers. The judge has discretion to consider new evidence. Okay. And a new round of affirmations can be filed for that purpose of that appeal. If you appeal further, so the original decision is given by master, right? Master in chambers, then if you appeal to a judge in chambers. If you appeal against that judge in chambers, you appeal to the Court of Appeal. Okay, but it is still called an interlocutory appeal because we're not yet at the main trial. Now, guess, can a party obtain summary judgment against the government? Guess. Just take a guess. Yes or no? No? Well, it is a no, and it is under, I'll give you the Rules of High Court Order 77, as in 77. Rules of High Court Order 77, Rule 7. Okay, no application can be made for summary judgment against the Hong Kong government, including those actions where the government acts in the private capacity. Okay, so even if they're not exercising a public function, you still can't get Order 14 judgments against them. Okay, we promise not to ask you that question during exam. Okay, it's very particular, just out of interest, it's just for fun, sort of. Can you give examples of what may be classified as practically moonshine defenses? Okay, short of saying, I saw E.T. Okay, I saw an alien. What else? What else can you think about? Something that is very inherently impossible, put up by the defendant as a defense. Ignorance of the writ. No, that's not a defense to the claim itself, though, right? It's a procedural matter, but as in a defense against a claim, it's a defense against a claim based on contractual breach or negligence, like you have as against the claim, is what I'm saying. I can't think of something. Yeah, anyone can think of something? Because I normally don't jot down these examples. Well, what if I said I delivered, well, you ordered goods from me, Doris ordered goods from me, this time I'm the defendant. Okay, Doris ordered some goods from me. She is alleging that she paid me, but I didn't deliver. Okay, I acknowledge, yes, I did get your payment, but I delivered your goods. And she say, when? Oh, I did put it there on Wednesday morning, 10 a.m. I even knocked on the door, but nobody was there. But let's say she was inside. Like, it's something very inherently impossible, or I'm trying to allege something, but I have absolutely no shred of evidence to support my claim. Okay, for example, I said, it's a shipment of goods she ordered from me. I'm supposed to ship to Australia, to Sydney. So I said, I shipped. Okay, show me the proof. She's asking me, show me the proof. Well, I lost the packing list and my carbon copy of the shipping order. So I can't find it now, but I shipped. That's pretty fishy, and there's no substantiation, right? Well, you may say, well, I'm not making a witness statement, I don't have to show all the evidence yet, but at least I have to show something. Okay, I say I shipped, but I cannot show one piece of evidence at all. I can't even tell her which which plane or which ship I sent the parcel through, or whether it's DHL or Sunfeng or, okay? I can't provide any material facts. That sounds pretty fishy, wouldn't you say? If it had been true, I couldn't have forgotten everything, right? I forgot, was it by DHL or FedEx? Did you keep record? No, I threw it away. I thought you got it. Right? That's pretty fishy. That's the kind of example I just thought about. Okay. Number 3, as provided by the RHC, an application for summary judgment may not be made until a statement of claim has been served and the AS, or notice of the intention to defend, given. Consider whether one may apply for summary judgment after a defense has been served. Yes or no? Actually, I've told you the answer. Well, I told you it has to be after the SOC has been served, after the AS has been filed indicating defendant's intention to fight or contest the case. Did I tell you the time limit? No time limit, right? No time limit. So can you do it after a defense has been filed by the defendant? Yes. But if a defendant has filed the defense and you are still making this application, you are also saying there's no substance in the defense, the document, the pleading defense itself. You're saying that's rubbish. Okay? So you would probably in your argument or your affirmation also argue that yes, the defense has been filed, but it doesn't really come up with any substantial defense to my claim. So it's empty. In other words, it's just no substance. So the last question, I think you know it by heart now. In what circumstances will the defendant be given conditional leave to defend? Well, conditional, right? Not as good to the defendant. So it's given if the defendant has raised some arguable defense or triable issues. Something's been raised. It's perhaps sort of believable, but not quite, very weak and thin, a bit suspicious. So, conditional leave to defend. Okay? Any questions? That's it. No questions at all? Okay. Good to go then. Okay, if you have no questions, I'll stay back for a little while longer in case you have questions. You can come up to the front.